the Commission that the Commission should accept those two affidavits and to take those affidavits into consideration when preparing its report and dealing with matters which it wanted clarity from him, and excuse him from having to provide evidence orally, as I referred to 11.6, which gives the Commission the discretion to allow a person to provide an affidavit or to appear. So I'm simply asking the Commission to dispense with the requirement of him having to provide evidence oral. Insofar as the requirement for him to attend, he has complied with it because he's here, but I was simply requesting that he be excused from the necessity of him providing evidence orally. And those will be our submission, and that will be our application. Thank you.
Thank you. Let me just say that there have been occasions early on in this Commission where I have written to Mr. Makakela to get clarity on pretty narrow issues, and he's responded, and I've written back to say thank you. I've noticed in the affidavit that there's statements, and you've said the same over here, that he has cooperated with the Commission. He suggested there that at all times the fact that I replied to him courteously suggests that I accept what he says. I don't think you should mistake courtesy for acceptance.
Indeed, yes.
The long letter that was written that didn't deserve a courteous reply, but it received a courteous reply nonetheless. So please don't mistake courtesy for acceptance.
Yes, indeed.
The second thing is, you're quite correct, the regulations give the Commissioner discretion. I don't read the regulations as suggesting that there is an obligation first to ask for an affidavit, and only if the affidavit is unsatisfactory to call the witness. It gives a discretion to the Commission to choose whichever route it considers most convenient and best. And I've noted Mr. Mapekela's view that we should accept that his affidavit is the end of the matter. I regret to say that that's not the case. He was given a directive to appear because the Commission considered that was the most convenient way to deal with a number of matters. Subsequent to that, he submitted the affidavit you referred to, in which he said, look, that should be enough. Well, thank you, we've considered that, but we don't think it's enough, so if you don't mind, we'd like him to argue evidence.
Yes, I mean, I've made an application to the Commission, so you must understand that to be the ruling of the Commission.
That is the ruling of the Commission that we'd like to hear his evidence orally.
The instruction is that if that is the ruling, that obliges him to provide evidence orally, notwithstanding the affidavits that he has filed, where he has dealt with the matters raised by the Commission. He'd like to exercise his right then to challenge that ruling in court.
Well, he's got every right to challenge it in court, but meanwhile, can we carry on and hear the evidence?
No, what you'd like to do is to challenge this ruling, because if he is to participate, notwithstanding that he doesn't agree with the ruling, is to defeat the very purpose of going to court. So what he's saying is that he would like to challenge, and the Commission is not a court of law. It is performing quasi-judicial function of some sort, and its rulings and how it conducts itself is subject to the court process. If a person aggrieved by its ruling wants to challenge it in court, and it will be grossly unfair for him then to Mr. Mapekela that he is to be prevented of exercising his Section 34 right, the right of access to court. So he would like to exercise his constitutional right, section 34, to access the court and challenge this ruling that in our submission it is grossly unfair to him. And we have not been provided with any reasons as to why Mr. Mpakela is required to provide evidence orally. And we have also noted that even the requirements of Section 6 of the Commissions Act have not been complied with. But those are matters that Mr. Mpakela will deal with in his application. So Mr. Mpakela would like to state categorically to this commission that is aggrieved by the ruling, and he would like to take it to court, and he should be given that constitutional right which should be vested in every citizen.
What you haven't mentioned before Section 6 of the Commissions Act, you said that it's irregular for him to be, that it hasn't been complied with. In what respect do you say that it's irregular to direct him to appear?
Now, I've said, Mr. Mpakela is the officer of the court, as elected to cooperate with this commission, and is also given an affidavit, albeit not entirely dependent on the directive which was issued. But I'm saying that what we are now confronted with, that Mr. Mpakela should be obliged to answer questions despite him wanting to go to court, is also grossly unprocedural, given the fact that Section 6 of the Commissions Act has not been complied with. I can take the liberty to read it to the Commission. Yeah. But it's not a matter that requiring the Commission to make a ruling on. I'm just saying that it's one of the matters that will canvass in court.
Well, if you say
Section 6 says, offences by witnesses. Any person summoned to attend and give evidence or to produce any book, document or object before a commission who, without sufficient cause, and in brackets says the onus of proof whereof shall rest upon him, close quote, fails to attend at the time and place specified in the summons, or to remain in attendance until the conclusion of the inquiry, or until he is excused by the chairman of the commission from further attendance, or having attended refuses to be sworn or to make affirmation as a witness after he has been required by the chairman of the commission or to do so, or having been sworn or having made affirmation, fails to answer fully and satisfactorily any question lawfully put to him, or fails to produce any book, document, or object in his possession or custody or under his control, which he has been summoned to produce, shall be guilty of an offence and liable on conviction to a fine not exceeding £50, or to imprisonment to a period not exceeding 6 months, or to both such fine and imprisonment. So what Mr. Mpakela sought to do here when I was making submissions was to demonstrate to this commission that he has provided sufficient cause, in which then we have not been provided with the reasons why his submissions do not constitute good cause. But Section 3, which deals with how a person is to be summoned before the commission, it states that that is 3 sub 2. A summons for the attendance of a witness or for the production of any book, document, or object before a commission shall be signed and issued by the Secretary of the Commission in a form prescribed by the Chairman of the Commission, and shall be served in the same manner as a summons for the attendance of a witness at a criminal trial in a superior court at the place where the attendance or production is to take place. So the directive that was issued is not a summons as contemplated in Section 3, but it was a directive that was issued in terms of Regulation 11.6. And the regulations which were promulgated by the President do not at all provide as an offense the steps or the posture that has been taken by Mr. Mpakela, which is to provide an affidavit, and if the commission is sort of satisfied with the affidavit, to compel him to provide evidence. But those are matters that we will deal with at an appropriate time in court, because the ruling has already been made, so I'm really then arguing ex post facto the ruling, which then really then does not take the matter any further.
I understand, but rather you raised an issue after the ruling had been made, and I thought we should just clarify that so that you can have a chance to be heard on that. But if you don't wish that, you don't have to have it. The Commission doesn't compel anybody. The directive, whatever the Commission's Act says, the directive was issued under the regulations. I haven't heard it said it doesn't comply with the regulations. The regulations go on to provide that it's an offence not to comply with the directive of the Commission. So I don't think the Commission's Act comes into it at all. The regulations don't say that the Commission may only ask for oral evidence that is not available on affidavit, as we've said. So I'm not going to change the ruling. The ruling of the Commission is that he should give oral evidence, because as far as the Commission is concerned, it is the most convenient way to deal with it, rather than going backwards and forwards with correspondence. And we would like to get on with it. If you're asking for a postponement of this in order to approach a court, I regret that you're not going to be allowed that. And we'll take a short break for you to consult with your client. And then if you don't mind, we'd like your client to assist us by getting on with the matter. I must say I fail to understand why an admitted attorney, as you rightly say, should not be willing to give evidence before a commission. And I'd like to accept your invitation that you issued, which was that he has and will continue to cooperate with the commission, and the cooperation we require at the moment is that he gives evidence.
Well, as I understand,
we'll adjourn for a few minutes.
I just want to, based on what you've said here, that I do not understand Section 3, or rather Section 6 of the Commission's Act, and as well as the regulations, to empower the Commission to force him to testify orally, even if he has made his submissions here. I understand Section 3, rather Section 6, to say that without good cause, if a person fails to do so, he commits an offense. The Commission is not the one who is going to decide whether he's committed an offense. The Commission is not a court of law. The Commission becomes a complainant, and the Commission will then refer the matter to the relevant authority to deal with it. That is how I understand the law. I don't understand the Commission to be a judge and a complainant at the same time. So all I'm saying is that the Commission does not have the power to force him to testify when he's made his point very clear, that he is not going to testify on the basis that he has provided through my submissions.
You're perfectly correct that I can't force him. There are no cells here. I can't call in the police. I can't lock him up. Perfectly correct. What I said to my ruling is that he should continue. You're quite right that it's a matter for prosecution. If he doesn't continue, and you can argue what you wish of the prosecution if there is one.
That is what I want to do.
Can you allow me to finish? But I'm saying to you that the ruling of this commission is that he should give evidence orally, and if he chooses not to do so, then he will face the prospect of a prosecution. But you're quite right, I can't tie him down to the desk there and interrogate him under in some way.
Indeed, so then that is what he's saying, that he will await the complaint by the Commission to the prosecution, but what he's saying is that he's going to take the ruling on judicial review that has been made by the Commission.
Well, he must do that if he wishes. If he wishes to wait for the prosecution, then he must do so. If we're going to take a break, we'll see when we come back whether Mr. Mapakela is going to give evidence according to the ruling, and that's the way we'll continue.
I've taken instructions already before this proceeding started.
We would
Unless
like
if he must then take them again, whether he wants to reconsider, then I can do that.
No, well, you can do as you wish. We're going to break for a little while.
So he's telling me that he's not reconsidering, and so then he is actually then standing by what
That's fine.
I've submitted.
We'll deal with it afterwards. We're going to break for a while if you don't mind. Thank you.
Indeed.
How are you guys? Aku stay pakai hati kita. Oh, okay. I can talk. Lelak pula kita mau dekat. Oh, okay.
As long as you are not doing it all the time on one, you can now have it.
Mom.
We're supposed to be finished. I don't know why we're coming back.
Okay.
How are you? Fine, and you? That's wonderful.
I love your girl.
Do you have it in front of you?
Yes.
The opinion given was that there was nothing in the National Intelligence Service.
Judge, which page?
Let me find it. Paragraph 49, page 24. Sorry. You have it?
Yes.
You see that comes after an analysis of the National Strategic Intelligence Act. And the advocates point out there that the key matter of the Intelligence Act is the protection and advancement of national security. It is clear that the purpose for which SARS collects information is not to protect or advance national security, but to administer and enforce tax legislation. You see that?
Yes.
So it says the National Services Intelligence, National Service, National Strategic.
Strategic Intelligence Act.
What is it called?
National Strategic Intelligence
The
Act.
National Strategic Intelligence Act does not prohibit SARS from collecting information. You see that?
Yes.
It goes on to say, if you go to
25.
at paragraph 50, on that basis, the information collected and evaluated by SARS for the purpose of administering and enforcing tax legislation does not constitute intelligence as defined in the NSIA, nor does it constitute departmental intelligence. Based on the purpose and the matter of the NSIA, we are of the view that SARS's activities in collecting information for the purpose of administering and enforcing tax legislation are not governed by the NSIA, nor does the NSIA apply to them. For that reason, SARS activities in this regard would not contravene the provisions of the NSIA. You see that?
Yes.
They also in here list the kind of activities that the Revenue Service may engage in. Do you have it offhand?
Sorry, what are you looking for, Judge?
There's one about they can go around driving cars and watching people and so forth. Yes. The list, if you look at paragraph 41, the list of special investigative methods provided to us to consider includes the following activities. And on 542, the general rule is that SARS may only employ methods authorized by the underlying statutory authority. It means that both the method and the purpose for which it is used must be underpinned by statutory authority. The authority may be express or implied. SARS has all the powers expressly conferred in it, and all such powers as are necessary or ancillary to its express powers. An important consideration in each case is also whether its investigation intrudes upon the rights of others, and particularly their right to privacy. A court would be less likely to recognize an implied statutory power if it intrudes upon the rights of others. The implications for SARS list of special investigative measures are along the following lines. 1. SARS may keep people under surveillance in the public domain, but not in private. SARS may follow a person or vehicle in the public domain, but not in private. SARS may probably place an electronic tracking device on property to trace its movements. It may, however, not place an electronic tracking device on a vehicle to follow the movements of its driver because it impinges on his or her privacy. SARS may watch a person or property such as business premises, residences, containers, etc., but only in the public domain. SARS may take photographs or videos of people or property in the public domain, but not in private. SARS may not listen to or record private conversations unless the SARS official is a party to the conversation. SARS may not electronically record third-party conversations by using listening devices. SARS may record conversations between SARS officials and third parties. SARS may accept information from informers on the basis that their identities will not be revealed. SARS may accept information from a person even if it knows that the information was unlawfully obtained. It may, however, not accept stolen property. SARS may not use other abusive practices or threats to secure any income. So you'll see that he lists there the activities that SARS may get up to, and those include what would ordinarily be called surveillance, provided it is within limits. You see that? That was his opinion.
Yes.
Given to the Commissioner on the 1st of September 2015. So I think that now we've now cleared up the two documents that were contentious. The one is, you've seen the Brassey memorandum that was written on the eve of the disciplinary hearings, and we've been through that, you know its contents, and we've seen that Advocate Tringrove gave an opinion in September following upon looking at the Sikakani report, and he said surveillance activities are permitted provided you keep within certain bounds. Is that okay? Can we carry on from there?
I suppose just on my side, Judge, I think at the conclusion of the last occasion that Mr. Libelo appeared before the Commission, he suggested that he had heard during the lunchtime or so, after he had been excused from testifying until he came back, I think on the 27th, he suggested that he had read these two opinions, both the Brassey opinion and the Tringrove opinions that you've made reference to, and suggested that counsel in her questions may have misrepresented the actual contents of those opinions. I just want to understand whether Mr. Libelo still stands by that assertion, and if he does, what's the basis of that submission?
And good morning to the Commission and to the Judge, and thank you for taking me through the two opinions. I think the only points I want to make on the two opinions, one is that the first one, all I was raising was that this document were not put before me.
Sorry? All you were raising? I can't hear you so well.
Was that is it better now?
Sorry, I just couldn't hear you there.
Okay. I was saying all I was raising is that the two documents which I was expected to respond were not put before me. And in reading them in the short period that I read, it did not imply what, when I was questioned, seemed to have implied. And there are two things. One is that the opinion of Advocate Tringrove was completely saying that the unit was not unlawful. And when I read it at the time that I read, of course it's written by senior counsel, it specified incidents that will be acceptable and incident that was not acceptable. And for me it meant that it depends on incident that happened, but it was saying SARS can do this, it can do that, SARS can do this, it can do that. So for me it was not saying that that cannot happen. The second one was that, and that's why with now that I've received the document, the second one, firstly, was not a legal opinion. The second one was a progress report. So when I received the opinion, when I received the document, I then discover exactly what happened in that meeting. So the impression that was created was an opinion. And the second impression was that Advocate Bracey wanted to remove certain charges, and I instructed him, or I kind of insisted on him to do that. So that is also not true from that document in my reading.
Sorry, you say it wasn't true. It's what Advocate Bracey says is not true.
No. I'm saying it not from my reading of the document. It was not entirely true.
Yeah.
That I said. I mean, I pushed there. And if I were to give clarity on that one, I then discovered that was a report from a meeting we held between Advocate Bracey's team, the attorneys that were briefing him, and myself. We was giving us a brief because they were about to do the charges. The question there was about the 3 charges, which he was saying they can't stand together. And I was advised, obviously, because we were sitting in a meeting. It was not like I was sent something and I responded. We were sitting in a meeting. And after discussions and with the attorney advising was that because they can't stand on their own, you can put them together. And Advocate Bracey was happy with putting them together.
Well, the question asked by Mr. Kashla, if we can come back to that first. You said you've suggested that what counsel put to you was not correct. Do you still maintain that, having looked at the documents? And if so, what basis do you say it was?
I've said the 2 bases, Judge. I'm saying the first basis was that the impression that was given to me was that it's a legal opinion, and it was not a legal opinion. The second basis was that Advocate Bracey did not want to continue with the charges about the rogue unit, and I instructed that he must not, as if he didn't want to, and I instructed that was not. And I was explaining that it was not a legal opinion. Secondly, it's not that I instructed him. It was a meeting that we had with him and his team, and it was the outcome of that meeting. So it was not me directing him not to follow on those charges.
Well, let's go back and make sure we've got an answer to the questions. You say the first one is that the extent to which counsel, you say, misled you was to call it an opinion when in fact it was a memorandum. Is that the problem?
Yes.
Well, if that's what you're concerned about. The second one is you say, and could I just turn to that memorandum of Mr. Bracey's? I don't think I have it. Do you have it?
I can read out the portion that's referenced.
And you say that she misrepresented to you that it said that you had instructed them that the charges should be proceeded with. And let me read the memorandum. Yesterday we recommended to our client SARS that of the 3 sets of charges currently being pressed against Mr. Pillay, SARS Deputy Commissioner, the charges concerned with the so-called rogue unit should be held in abeyance. Our advice was premised on the fact that the evidence, so far as we've been able to gather it, is far from conclusive on these charges, and that witnesses who might be called to substantiate the case were proving to be uncooperative. In response, our client, represented by Mr. Luther Labello, has instructed us that all 3 charges should be pressed together, and we happily submit to such instructions. So he says that you had said, notwithstanding my advice that they should not be proceeded with, you had said proceed with them in any event. That's what he says. Correct?
Yes.
And now that's what counsel had put you, that's what he had said. So where is the misrepresentation to you by counsel?
I'm saying that the cross-examination that was put to me was creating an impression that there were charges that Advocate Bracey didn't want to proceed with, and I overruled him. And I'm saying
what this says.
Yeah, but I'm saying that it's not. There is a difference between what is written and what happened. I'm saying what happened.
I understand that, but that's what she put to you from the memorandum.
Yes, I'm saying.
You're saying, well, sorry, let's just get this correct. You're saying that what Mr. Bracey said is not correct.
No. I'm saying the context. After I saw the opinion.
Yes.
And at the time that I read it.
Yes.
And when I reconsidered, I remember this was a meeting. It was some kind of a minute, if you like, of saying, we had this meeting, this is a progress report, we raised this with the client. You could have used any language. I'm saying at the time, there was a discussion and the meeting agreed that it will be better if you compress the charges together. It was not me saying it.
Well, I want to just...
But I'm saying, Judge, because I don't want us to really get stuck here. I'm saying that's my view, that the impression that was created was that I stopped the charges. I went back to this opinion. I found that it was a meeting, which meeting all of us agreed that you can compress them together. It must not be reduced into me, but that's my view. And
I'm still interested in your answer to Mr. Koshler's question. In what respect did counsel misrepresent to you what was contained in this memorandum?
I'm gonna respond it for the last time.
No, you don't have to do it for the last time. Just tell me the answer this time.
I gave the answer.
She put to you what was in the memorandum.
I gave the answer, and I'm going to give it again.
No, you're not going to give it again. You're going to listen first to my question, if you don't mind. She put to you what was in the memorandum, correct?
No.
Sorry, she put to you what was in the memorandum. Do you agree or don't you agree?
I'm saying the impression that was created was that he did not want to proceed with the charges, and I overruled him. And that was the impression that was created on the cross-examination. And I'm saying that impression was incorrect.
She put to you what was in the memorandum. Is that correct or is that not correct? It is yes or no.
She put that on the memorandum.
Yes.
She proceeded to cross-examine me.
Yes. And
I'm saying the nature of the cross-examination and the impression created by the cross-examination created that impression, which I found that it was incorrect.
Yes.
Because she didn't ask me one question. She asked me a question, and she made follow-ups, and she made follow-ups. And I'm saying those follow-ups created that impression. And that is my view. If the commission doesn't agree with the view, I think that's fine. Well, but that's my view, and those are the two answers that I give.
Okay. Is that okay, Ms. Steinberg?
I would just like you to clarify, Judge. I don't understand a memorandum to be minutes of a meeting.
Well, whatever they are,
yeah.
You put to him, as far as I can remember, and you'll find it on the record, you said that's what the memorandum said, and you put to him what the memorandum says. Whether the memorandum is accurate or not is another matter. I didn't understand you at all. To say I know more about this than I've heard, you put to him the memorandum, we know what the memorandum says, and we've heard the explanation, which is not that you put anything inaccurate as it was contained in the memorandum. So I think we'll leave it at that, if we may. Is that okay?
So just need just some clarity, Mr. Libelo. Are you suggesting that counsel suggests, that is Bressy, that the charges should be compressed together? Because what I read out of the memorandum is that in relation to the so-called rogue unit charge, he expressly said it should be held in abeyance. And it sets out that the basis for his suggestion that it be held in abeyance. And then completes this by saying that you then pressed that they should be, you then instructed that they should be pressed together. So the comprehension together is actually on the submission of, on this memorandum, was by yourself, not by Advocate Bressy.
Yeah, but so if you go further and read the memorandum, it also tells a story. It tells a story. If you look at paragraph 5.3, it tells a story of Mr. Johan Dival will come, and all I'm saying, and this is the evidence I'm giving, I'm saying, when I looked at the memorandum and I considered what happened, is that there was a meeting where we were given feedback. I was with my attorney, and maybe the judge will know that when you're sitting with counsel, you're sitting with an attorney, sitting together, we're planning a case. We talk as a team. It's not like there was an email sent to me and I gave instructions. So that was the discussion that we had, and that was the proposal that was put there. And Advocate Bressy is even saying here that we happily complied. And I can assure you that Advocate Bressy will never be instructed by me to continue with the charge that he doesn't believe he's going to do it, because he's the one who was going to do it. I took advice of the general meeting that was there, and of course, because I'm a client, that becomes the client's advice, and that is how we work as we brief counsel.
Yes, I've seen your explanation. It's also contained in your affidavit, the explanation you've given. Now we've read that. It's fine. We'll deal with that in due course and weigh it up with all the other evidence. May I just clarify one thing as well, and I think it's fair to you, SARS, and to you to do so. As I understand your affidavit, the initial bill you got, account you got, for collecting, I think it was those documents, those 2, 4, 5 files there, was 1 million rand. Is that right? And it was
can I deal with that?
No, just answer the question. Is that correct? I'm
Yes.
looking at your affidavit.
Yes.
It was first about 1 million rand. Is that right?
Yes.
And then you negotiated it down to 759,000 rand. Is that correct? And that has not yet been paid by SARS. Is that correct?
Yes.
And you are still in discussion with the attorney as to whether you're willing to pay that amount. Is that correct?
Yes.
Okay, I think we've dealt with that now. Is there anything further you want to deal with?
No, Judge. No, we accept that Mr. Libello has now given a full account of the evidence in these files, in this affidavit.
Well, he's given an account of how he interprets
Of how he
it.
interprets it, yes. And we accept, as you've said many times, that on the information given to Mr. Brassey at the time, he drew up a charge sheet and he was willing to prosecute. We accept that.
Yes. Okay, well, I think that's, is there anything further that anyone else wants? I don't think so myself. May I just address your attorney for one moment? And that is, we have the affidavit. We will evaluate. It doesn't mean that everything in here is relevant to our inquiry. We will evaluate it and take account of whatever we think is relevant to the inquiry. We will look at that together with all the other evidence and weigh what is said there with the other evidence that is relevant to the inquiry and reach our conclusions. Is that in order? Is that in order?
Yes, it is.
Thank you.
Judge, Mr. Libello would like to address an issue that is contained in the affidavit, and it relates to yesterday's newspaper article about this invoice that we have just spoken about.
Yes, well, I
There
don't
is
know.
an article.
I don't know what was in the newspaper myself. I was told there were some reports, but
Yes.
you say you want to address it.
Yes, Judge, and thanks so much for allowing me. And I must say that is one of those that I want to address because it was very unfortunate. So, in the evidence on Friday, a statement was made that I have spent 759,000 rand to come and clear myself before the commission on my own cost and all that. And it was ran all over the papers on Friday and Saturday and Sunday, and it has caused so much damage and pain purely because it is not correct. It has really cast an expression on me very badly. Now let me explain it because it's deep. And I'm leaving the issue about the agreement or the no agreement. My understanding is that I had a conversation with the judge a number of times, and I realized that the evidence that we had was not sufficient to converge between what I thought I had and what the judge had. And in that meeting, and I'm saying this, and I'm talking about my own understanding, without dragging the judge into it, that I then said the best way is to maybe get the files that existed at the time of the disciplinary, so that I don't say I know this and then the judge said I was told this and whatever. And I left, as per the new policy, I filled up a form to the head of legal, Mrs. Rufilo Mukwena. That is how the process works. And as you can see on the form, which is attached here, I make it clear that this is for the purposes of the commission. So I say the short description is that compile a report and full files on the following matter on which you were instructed. And I mention the names of the employees. And I say, I'm just looking for that part. And I say, this compilation files is for the Commission of Inquiry. And I might not be factual here, but I remember I even said to Mrs. Rufilo Mukwena that she must check with the commission before she approves because it's coming from the commission. So at all material times, I understood that I must get this information so that it helps the commission. The files were as per the disciplinary action that took place at the time. So my expectation was that the disciplinary action was stopped 5 days before. There should be files sitting somewhere. Somebody must go and dust them off and give it to the commission. So that was my understanding.
Okay.
And the file went. When when I was told by the same firm that the files will be ready on Friday, I wrote an email which is in the affidavit. I said to the judge, Judge, thanks that I hope you had a good break. And as per the discussion on that day, the files will be ready on Friday. Can me and you meet so that I can take you through, I can give you the file, either take you through or whichever way. So I gave options there. And this continues to show that I never for a moment had any other aversions, but that is what the commission needed. I met with the judge.
It was what you felt the commission needed.
Yes, I'm continuing on that note.
Let's get that
at
perfectly
all time,
correct.
at all times.
Blame me for spending $1 million.
No. I'm saying at all times,
yes.
From the conversation, from the forms, from everything else, is that the files were for the commission. I would not have went and filled up the form and asked for SARS information for myself personally. It's against the law. I can't do that. I can only do it on behalf of SARS. When the files came, the judge will remember I met with him twice, taking him through the file the first day, and the second time also we met, and I took him through the files. And on the basis of the file, he made a decision that I must come and present at the commission. Probably a few days before I appear before the commission, I received a bill from the same law firm, almost to the amount of R1 million for the files. And I was shocked because all I thought is that if you're about to charge people, it means you've got files with you. And my instructions were clear. Just retrieve the files. So I thought people would just go get the files, clean it up, maybe make 2 copies and bring it here. So I didn't even expect it to be so much money. I then wrote a letter back to the law firm and I said, there is something wrong with this invoice for my expectation. The email is in the, I'm not quoting the verbatim, is in the file. I mean, it's in my affidavit. The law firm responded and said, we apologize, we did a mistake, we didn't do quality check. They reduced it from that to 759. I appeared before the commission. Unfortunately, I had to leave for a family event. When my office was insisting that I must sign it, I said, no. Even though they've reduced it to 759, I still cannot fathom, I cannot comprehend that retrieving files that were ready at the time of the hearing can cost so much money. When I come back from leave, I will then send them a letter again and say, now that you've clarified your quality errors, clarify for me how can files that are supposed to be in a cabinet cost you so much money. When I was on leave, the commission told me that I must appear today. I asked the commission whether there is anything extra. And then I was then presented that I must come and explain this invoice. So I knew that today I'm going to come here to explain the invoice. The important thing about the invoice is that I didn't sign it because I was lodging a complaint. I even said to my colleague that this is one of the invoices that we must even take to the Law Society if you like, but it was said in jest that we need to argue about it. But unfortunately it was there. I still don't know how can an invoice that was in my office and my office was locked ended up in the commission, but I don't want to get into that. The fact is that it get into the commission. I was coming here to respond to it. Unfortunately on Friday a statement was made which statement cast an aspersion on me. But the important principles are that the invoice was brought to me from people who were supposed to just retrieve the files that were existing. It was exorbitant. I questioned it. They reduced it. I was going to question it again until I get to the bottom of the matter. So that invoice is on record. So I thought, let me clarify that because the impression that was created and the noise that was ran on Friday was that I personally did the following things. Now, let me also clarify some little thing that appeared, which I thought the acting commissioner might also been confused in the fact where he said, I was given legal representation. The legal representation that is here is not Mashiane. The other one is Mashiane. And the reason why we had to go to Mashiane Mutli for the files is that they were the attorneys that were instructed to work. So you can't go to any other attorney. It's only them who can help. Now, one of the things that the acting commissioner raised here was that I was given legal representation. Indeed, it happened. So one day in our conversation between me and him, he told me that some other senior person has requested for legal representation to appear before the commission. And I told him that I thought about it, but I don't think I need it. And he said, no, I think you need it. You must send an email to Mr. Makungum Tebule and ask for a legal representation, which I did. Is in the affidavit. And then they responded and said they're going to give me legal representation as one of the things that EXCO has given, that if an employee needs a legal representation, they must ask. I never thought I needed it until I had a conversation. Now, the problem with that is that they only came to me 2 days before I appeared before the commission, the last time. So I had two options. The one option is that I asked the commission to postpone, which I didn't think it will work. But the second option is that if you are told that, okay, get lawyers 2 days before you appear, what will happen is that by the time you meet them, if you sort a date and stuff like that, you'll be appearing to the commission. So I called my colleague Aluwala. I said, look, given that it's only 2 days, 2 full days before this, I don't think it will be prudent for me to use the lawyers. Otherwise, I'll pay them for only consultation. The files are many. And on the basis of that, let me go there without the legal representation. And I came before the legal representation. And when I was here, I then said to the commission that given what happened, I think I'll need legal representation. I went back. I sent an email to Aliwale, CC, the acting commissioner, and I said, look, you know I came back from the commission. Now I think I'll need the legal representation. He told me that, no, that's fine. They'll use the insurance that SARS has with lawyers. And I can choose any lawyer that I want. I even emphasized to him that please give me the same set of lawyers that you can give. And I was told that you can get an attorney and a counsel. And I was given an attorney and a counsel. So the lawyers that are personally representing me here are the lawyers that a decision was made by EXCO and acting commissioner that you can get if you want the legal representation. The one of Mr. Mapagela, the only reason why the files have to be sought from them is purely because they ran the thing. So really the impression that was created in the public there in the media is not correct. My intention, and I'm saying it here, that we're going to go to, and I'm using the word loosely, we're going to go to war about that invoice, because I still need to get answers as to how does files that are expected to be sitting somewhere in a cabinet tend to cost us so much money. And
those are the files you presented, yes. 5 files.
Yes.
Well, that's about 200,000 rand a file, I suppose. Yes.
Yeah, I don't know. The other thing, Judge, that I want to just conclude on, and I didn't...
Let me interrupt you and say that the fact that you have got counsel or attorneys with you today is not an issue. The Commissioner has said anyone who wanted to have an attorney or counsel with him or her giving evidence, perfectly in order, so that's not an issue at all. I don't think that there's anyone suggesting there's anything wrong with that.
Okay, I'm just closing that. I'll be submitting. It's not part of the affidavit, but I'll be submitting 1 or 2 emails that will answer 2 things that happened in the previous one. The first one is about 2-3 emails that we sent in 2016. Complaining to the office of the commissioner at the time, Commissioner Moyane, about the issue of the invoices. You'll remember there was a question about why do you pay invoices that are not within your purview. So I discovered now that there are a number of emails where I sent to him and said, but this is a problem. There are emails about a lot of things that we don't know, and this is a problem. And then I'm sure I had about 2-3 emails where we complained as far as 2016. And then some more email, he responded to us and said, guys, just pay. So I wanted to answer that other aspect. The other emails that are here that we'll also submit is to also demonstrate that as early as 2016 and that around those times, we have sent emails in particular, but they are only for Mashiach, just to demonstrate that the battle about fighting for invoice, we've been having that battle since 2016. My team knows that when an invoice lands, they must go through an invoice. If they're not happy, they must question that. You'll see there that there are areas where the law firm, in particular Mashiach, had to cut some of the cost, they have to reduce some of the cost, and have to give away some of the cost on the basis of the battle that we put to them. So I'm doing this so that it shouldn't create an impression that when things happen in our office, we don't contest them. But that's all I wanted to clear, Judge. Thank you so much.
Okay.
Judge, I simply want to give the basis of the evidence that was put to Mr. King on Friday. There are 3 documents. The first is merely a transcript of Mr. Lebello's evidence. The reason that the impression was created that the files were prepared for Mr. Lebello's benefit rather than SARS is because on repeated occasions in his testimony, Mr. Lebello said that he had come to clear his name. And I want to read one extract. I quote Mr. Labello, "The reason why I'm here, the major reason why I'm here, is that over a couple of years, and I can say roughly 4 years, a particular narrative has been created, and if you like, ratified, which suggests that either myself, I participated in what is known as a purge, some of my colleagues whom I worked with for many years, which I had a good relationship with, where I was used in that place to purge my colleagues." And it goes on, "I was quoted as a Moyani hitman, and if I don't come and tell the truth and the story that I know, the stigma of being a suspension hit and being a purger will continue the rest of my life." And there are many, many examples where Mr. Labello said he'd come to clear his name, and that was the basis, one basis, of why the advocates of this commission had understood that these files were less about SARS and more about Mr. Labello.
Yes.
Now, when it comes to the instruction to Mr. Mapakela,
Just a minute, Ms. Steinberg. You know, I don't think we should enter into arguments at this stage. I accept that it was on the evidence. I'm well aware of that, the evidence you've read. We will weigh up what he now says against the evidence that was given, and we'll make a decision. But I don't want to enter into argument at this stage, if you don't mind.
I need to be clear. When there is an accusation that there was a misrepresentation from counsel, I need to clear that up. I have to have that on the record.
Well, you've put it on the record, I understand. What else is there? We've just discussed where the misrepresentations are alleged to have occurred. He's told us we've dealt with it.
I'd also like to put on the record that when one looks at the legal instruction Mr. Labello gave to Mr. Mapakela, it's not merely for full files, it's also for a report.
Yes.
If one looks carefully at the invoice that goes on for pages, that comes to 759 million rand, collating information is merely one aspect of it. What Mr. Mapakela is doing according to his invoice is he is making a case and he is writing submissions for Mr. Labello to come to this commission. He's asked to link evidence, to explore evidence, to investigate evidence, and to put it into a report. And there are repeated meetings with Mr. Labello. So it's simply inaccurate to say that all Mr. Mapakela was asked to do was to put together these files. That's not the instruction he was given, and nor is it what his invoice reflects.
Well, let's deal with the two separately. You recall that in the evidence, you had said on a number of occasions, on the last occasion, that you are here to clear your name. Isn't that correct? Is it not on the evidence? Well, just a minute. You've heard the evidence read to you. You don't have a transcript of the evidence? Do you have a transcript in front of you?
No.
Well, can you give him that section of the evidence, please?
Okay, I'm advised that it is there.
Okay, so that's the point she's making. You accept that you did say you're here to clear your name?
Yes.
Yes. Okay.
But that is not...
Is it not correct?
No. Let me explain that part.
Okay.
And unfortunately, Advocate Stenberg was not part of the meetings that we had between myself and the judge.
And, sorry, between yourself and?
Between yourself.
What's that got to do with that evidence?
I'm explaining it.
No, what has it got to do with that evidence?
I'm saying that the conversation about my purpose of coming here, I had that conversation with you.
Well, our conversation is not in the evidence. She's talking about the...
I'm not saying that, Judge. I'm saying...
Can you let me finish as well, Mr. Lupillo? Then we'll understand each other. That evidence has got nothing to do with any conversations with me. It's got to do with what you said your purpose was. And that's what she's asking you about. You said there, I'm here to clear my name. And she says...
Let me clarify that. In the affidavit, I've attached an email sent to the judge explaining my purpose of being here. Is in the affidavit. That is number one. Number two is that on the 28th, the judge asked me the same question here and said, Mr. Labello, you said you are coming here to clear your name. I responded here and said, no, Judge, it's not correct. I'm not coming here to declare my, to clear my name. It's on record that I said on the 28th. If you look at my submission when I started, I explained my role, I explained my purpose. The issue about clearing my name is, it comes together. I was saying that colleagues came to the hearing, gave evidence, which evidence included the fact that they were patched. And I was saying that after hearing that, I want to come and give an alternative view to what the colleague said. As the head of ER, and consequentially, I've been alleged to be a hitman who have suspended people. I even said to the judge, in the evidence it will show that I was not even involved in the suspension. But I think the evidence that has been put here is that all I'm saying is that I came here, I've never had in my head the impression that I'm coming here solely to clear my name. I always understood that I'm coming here to share the information that was in my knowledge at the time of these activities happening. In the affidavit is also explained better in the introduction about that part. Interpretations can be made, but I want to emphasize that when I started on the 27th, I openly explained why I'm here. The judge asked me on the 28th, and I corrected, and I said, no, I'm not here for my personal whatever, I'm here to share.
Well, there's the evidence. You've had your explanation.
Yes.
We'll weigh it up in due course.
Thank you, Judge.
The second issue you raised.
The second issue, Judge.
Well, let's just clear up what the second issue is, if I may, and then we can be quite clear. You see, it's one thing that one would like to have asked Mr. Mapakela about, but he prefers not to be here. And that is, if you look at this, I think that's the point, if you look at this invoice, you'll find, for example, where's the invoice? Do you have that invoice?
Yes.
See, under 2nd of August, working on notes and submissions to be made by Mr. Labella before the Commission. Attend to prepare for the presentation to be made to Luther in preparing him for the appearance at the SARS Commission. Dealing with the suspension of Richer, linking Richer to the unit, linking Richer to the recruitment of von Rensburg, linking Richer to Project Sunday evenings. You see, what she's talking about is they are being asked to make an investigation and prepare a case, as it were, against the people. Drafting submissions and notes for Mr. Labella in respect of Richer. Compilation of the file in respect of Ravelli. Discussion with Mr. Labella with regard to the need to hand over the file. Discussion with Mr. Labella and acquired further clarity seeking questions by the Honourable Judge Nugent. Well, I certainly didn't pose questions to him. So we go on, and then if we can go to the letter, you'll recall that Mr. Mapakela then wrote a very long letter to you. Remember that letter on the 22nd of August? You have that letter? The letter by Mr. Mapakela to you on the 22nd of August, very long letter.
we do have.
And that's the one that he sent to you, but he copied to me. Remember that letter?
Yes.
And he copied it to me. I think his explanation for some of it, he says that he took the opportunity unilaterally, he thought, to advise me on how to conduct the inquiry and not to be biased. Remember that one? He said as a collegiality, he said, thought he better advise me. And in that letter, as you see, there is a whole analysis of documents. He's tried to establish a case against these various people. You see that? So I think that's what counsel is saying. He wasn't merely instructed to collect documents. It seems he was instructed to extract from those documents a case to be made against these people. What do you say to that?
No, and the difficulty with this invoice is that it's in dispute. There are a lot of things that I see here that I don't even know.
Yes.
But I think the important thing is the page 9 of the affidavit that talks to the instruction. To say, at the time of giving the instruction which I signed, what was the instruction? And that's why I'm disputing, because it must collate with instruction. Like the letter that he sent to you, I don't know how he wants to charge it here, because I thought it was a letter from him to you.
Him to me?
Yes.
It was addressed to you?
No. If you remember, Judge, if you look at the letter, he says, "Dear Judge," then he goes and tells you a lot of stories. He was
it says Mr. Luther Labello, Group Executive, Dear Sir, 22nd of August. Where does it say, Dear Judge?
If you look at the letter, and we'll look at it, because it must not distract us, but we'll look at the letter. The point I'm making is the instruction that I gave, and maybe this is an instruction that I must read for counsel.
Yeah.
Request to compile a report and files on the following matters to be submitted to the commission.
Yes.
I mentioned the names. So the intention was that you take the files and then you compile the report for the benefit, so that you don't give raw files. So you'll say this file include the following things, and this was the evidence, exactly what I was trying to do last time.
Well, that's an index, but what's the report?
No, not an index. A report of explaining the files. So you must explain and say, this file is for that, this evidence is for that evidence is for that. It's an index, but in a form of, that explains the files. So that was the instruction that they were given to do. And then they went, I don't know what was the response. Unfortunately, I hope that they were going to explain it here today. But I don't know what is their response. But all I'm saying is that there are a lot of things that are here which I'm disputing, and I'm going to dispute with them, because I don't know how they relate to the instruction that I gave. My instruction was very clear. You compile that thing, you put a short report that helps the commission to understand how the evidence linked to each other. So
how the evidence does what?
Linked with each other.
But why is he explaining why is he trying to make a case?
No,
explaining how the evidence links to each other. I thought your instruction was collect the documents, put them in a file, and then I want to present them to the judge. Is that the instruction?
Yes.
So why was he going about trying to create a case?
But that's the part he must explain. Well, because that was not the instruction that was given to him.
Do you say your instruction was simply gather the files and present them? And so his invoice, you say, is not true. When he says, I met with Mr. Labello and we discussed this and that.
He met with me to take me through.
Take you through the files?
Yes. To explain which file is whatever. So meeting with me is true. The part that is a problem, because obviously he didn't just drop the files, he spoke to me. The part that is a problem is he went and digged, he went and listened to audio, he went and did the following things. My understanding was that the hearing was about to be sitting. You have got a file with evidence you are ready to prosecute, and that is the file that you wanted. We didn't want reconstruction of the files. That was not what I understood.
Well, he certainly gave reconstruction of what he said the file contains.
Which is exactly what you must explain.
And you say it's not your instruction. Do we need to go on?
No.
Thank you very much. Anything more?
Just two things, Judge. Firstly, just a quick one around these invoices. Did I get you right that you said in your evidence earlier that you've had a history of having issues with billing by your attorneys, by these particular attorneys?
Yeah, I only picked up for these attorneys. I don't know whether they are.
No, I'm talking about in relation to these, the ones that the ones who compile for you
The ones
those
that came
files.
here this morning, yeah.
So this issue you have around billing in relation to them is not an isolated case.
No, and it's not the first time.
Okay. The next point I wanted to is just to understand that I think it's helpful that you will be providing us with an email reflecting instances where you had difficulties around instructions to pay for matters that you could not connect to SARS. Am I understanding you that if you get an instruction from someone at the top, regardless of that instruction being lawful, you would simply just execute it? So if in this instance, if the commissioner wanted advice on a book in relation to him, and you find that that book has no relevance at all to his work as a commissioner, and you're required to pay for that, would you consider that part of lawful responsibilities that you've got to execute, that you must pay that invoice?
No, maybe I'll submit the email. So you'll see in the emails that where we went, we'll complain and say two things. These invoices were not part of, and they're not, obviously we're not using the same language, but complaining that we're not part of these invoices, that they're not touching on the issues that affect us, and we're worried about that. Then in one email, then he responded and said, just pay. And once he says pay as the accounting authority, that becomes an instruction that he gives us, that he pays because we pay from the budget. I think the important thing for us is that the struggle of us being expected to pay invoices that are not falling within our purview, and or we're not part of the instructions, we've been raising with the office of the commissioner, and that proof is there, which I'll supply to you.
And you say he responded in writing that you must pay those invoices that you queried?
Yes.
Did you query the invoice with him which said to the attorneys, I don't know what they charged for that one, 30,000, 20, you were reading the book? Did you query that with the commissioner and say, look, why are you instructing an attorney to read a book in order to find what it says about me, the commissioner?
No.
Did you query that?
No, we don't question that.
Sorry, did you query it? Is the answer yes or no?
Judge, I'll have to check. But what I'm saying is that the context of the query is that you are asking us to pay for a consultation with Mr. Kettler. We're not there, and it doesn't even look like it's an ER matter. And then he responds. So on that specific one, I don't remember whether I said to him about the book and stuff like that.
Well, that invoice was paid.
Yes.
And was paid from your cost center. Well, presumably you approve payments from your cost center. You don't just pay anything.
Yes, and that's why I'm saying in the emails it will show in instances where we complained and we were told that we must pay. That's all I'm saying in the email.
Not complain to the attorney about the amount, complain to the commissioner about why are we in ER paying for someone to read a book for you?
Yeah.
You say there are emails to that.
No, not specific, Judge.
Not specifically.
All I'm demonstrating is that there were emails where we complained about this pattern, where we were expected to pay for events that were not part or events that are not related to ER. I'm demonstrating that we had that struggle with the office of the commissioner, and at some point they send an email that you must pay. And obviously if you send an email that you must pay, you don't ask again. You just say, okay, it means he wants us to pay. Okay, it comes from his budget.
You'll provide us with the email?
With the yes.
And in particular, reading a book?
No.
Will you look if there's an email from you saying, please, we don't pay in ER for reading books? And can you please tell us why we must pay for reading a book? You will look and see if there's
Mr.
Bello, you're not listening. You will look and see if there's an email about that as well.
Yeah.
And you'll give us other emails where you've said to him, we shouldn't be paying this. This is your personal affairs, and we're not paying for it.
Yeah, not in that specific language, Judge.
Sorry?
I'm saying not in that specific language, but the judge will read.
In whatever language it might be, you'll tell us.
Yes.
The cost for reading the book, Judge, was approximately 120,000 before VAT.
120,000 rand?
Yeah.
How long is this book? Is it War and Peace? How long is the book?
I haven't read the book, no.
Do you know about this book, Mr. Miller? Do you know about this book?
Well, Judge, I explained that I was seeing the invoice about the book for the first time.
Yeah, okay.
All I did was to ask,
yeah.
And I didn't know about the book.
But you would have approved that, you say?
Yes, after I asked whether the work has been done and
Well, you'll show us where you...
Just one very quick question. Advocate Steinberg read to you a long invoice, lots of notations. Is your contention that in doing that work, the attorney exceeded his mandate, he wasn't asked to do the work, or he didn't do the work and charged you for it? Which is the two?
I think he did too much more than the instruction asked him to do.
So he exceeded his mandate quite significantly.
Yeah.
So where he says here, drafting case for Mr. Lebello...
I'm advised that I must say possibly.
You say possibly. Well, I don't think that you can say positively. It either happens or it didn't happen. Okay. So let us listen now so that we don't get confused. And I think that your attorney shouldn't tell you what evidence to give. He should tell you what you may not answer. That's different. But I don't think he should tell you what evidence to give. Where it says, for example, continuous drafting of the submissions, you say that if he in fact was drafting submissions, that was contrary to his instructions. Is that correct?
Yeah, Judge, I need to go, all I'm saying is I need to go through the invoice. If I were to answer the question is that in my looking of the instructions and all the other things that have been done, he exceeded the mandate of the instructions. My expectation is that if you are to be charging a person in a week's time, you have got a file that is ready with everything. All I was asking is that go to your cabinet, if you may, get us those files from the cabinet, and you shouldn't listen to tapes and all those things.
Well, will you go through the invoice and mark those which you say he exceeded his instructions for us? Could you do that?
Yeah, when I get to the office.
No, indeed, not now, obviously.
Yeah, okay.
And then will you also just tell me, when he wrote this long letter, analyzing the documents and saying it proves this, it proves that. You know, remember that letter we've just been through?
Yes, I will.
When you got that on the 22nd of August, did you go back to Mr. Mapekela and say, what on earth are you doing producing this report, this analysis, and trying to show why the documents proved a case against these people when that was not your instruction? Did you go back to him on that?
I didn't.
Sorry, did you or not?
No, I spoke to him on the phone.
Did you say to him, did you say to him, why are you sending me this report?
Can I say what I said? Because it's difficult to say, did you say this?
Yeah, okay, it's here. But provided I get an answer.
The only part that I raised with him was that my understanding was to answer whether the opinion is the last one or there's another one.
Yes.
If there's another one, you must give me the next one.
Right.
I was just, and I'm saying this without prejudice, because I was talking to him on the phone.
You can't talk without prejudice under oath.
Yeah, I was talking to him on the phone and I said, I thought you went a little bit where you're not supposed to go. But my understanding, and it's another contention, my understanding was that he volunteered to give the judge's views. It was not an instruction. Mine was a simple question of whether the opinion, there is another opinion, if it's there, just send it to the judge. I think he went a little bit more, and it was not an instruction. And if he's going to charge us for that, it's something that I'm going to contest, because I thought he was giving you a free...
free advice.
Free advice, yeah.
Oh, well, thank you. Thanks. Mr. Steinberg, I think, my own view is that these are important things, but quite frankly, we're involved in rather more important things. Don't you agree?
I agree.
And that is the running of SARS, this major institution, and what should happen in the future. So thank you very much, Mr. Lebello, and I hope that you don't have any more consultations.
Thank you.
Thank you.
Judge, we resume at 9 tomorrow morning.
Thank you.
We'll have to take it out. Do the cut same stand. But if he's